Hi, my name is Joel Denning. I'm an attorney and I practice law here in Baltimore County and throughout the Baltimore area. And today I'd like to talk to you about bankruptcy. That's the topic of the day. And today I'd like to ask my friend Rob Stahl here in Lutherville to help me out with some of these questions.
Well, Joel, let me say, first of all, thank you for asking me to join you today. Happy to discuss, any questions we have in the bankruptcy area.
Well, Rob, I want to hit you right off the bat with one that seems to be the first one that comes up. When somebody is about to get their wages garnished. Now, what does that mean in plain English? That means that somebody has just been sued, a writ of garnishment has been put into their place of employment, and they're about to lose a large chunk of money. And that person calls in quite a frazzled state, wanting to know if bankruptcy can help them and what's involved. Can you explain that situation?
Well, first of all, by filing a bankruptcy case, it stops all legal actions against somebody, as we'll call them a debtor. It stops all legal. It will stop wage garnishments, IRS levies, bank account seizures. We can stop foreclosures on your principal residence.
Let me ask you, if a person has already gotten a judgment and now they're threatening you with the garnishment, that judgment, can that somehow be stopped? Can you file a suggestion of bankruptcy to stay those proceedings? How does that work?
Yes, once we file the initial bankruptcy case, then we're able to file a motion with the district court where the judgment is, or the circuit court, and we can stop any further legal action by that judgment creditor. Once the bankruptcy is filed and the person ultimately gets a discharge in bankruptcy, that judgment will be eliminated from the court record and the debt will be discharged.
Okay, now,
and of course that'll stop the wage garnishment too.
I don't want to get too technical here because I know that there are lots of rules and they involve whether or not the judgment creditor had the lien in the husband and the wife's name, whether the home was in the husband and the wife's name, and there are a lot of questions of whether or not the lien attaches to the house. These are kind of difficult questions. Do you think a person would know how to go about dealing with those questions, or should they seek the help of an attorney? I know you can file a bankruptcy without a lawyer, but what is your opinion about that?
If you have judgment liens that attach to your real estate, you really should have competent legal counsel to file the bankruptcy case and then file motions to avoid the lien through the bankruptcy court.
Well, let me keep going with complicated questions. We know that there are secured debts and we know that there are unsecured debts. The secured debt would be something like a car, and the note, the car is the security for the note, and the house is collateral for the mortgage. When you're dealing with a car, for example, what are your options with a car? And let's assume that you're underwater with the car, so to speak.
Well, if you owe substantially more on the car than what it's worth, you have a number of options. You could surrender the car in the bankruptcy process, and the bankruptcy case would discharge the debt on that car. So you could walk away from that particular instance. Or there are situations where in a Chapter 13 filing, you could cram the debt down and reduce that debt down to the value of the car. In a Chapter 7, you have the potential to do a redemption of the car for what it's worth, and in doing so, you can get rid of the portion of the debt that's undersecured on the car. There are a couple of options. Although a question that we're always asked is, well, I want to keep my car. If I file bankruptcy, can I keep my car? And of course, the simple answer to that is yes, you can keep your car. You just have to be able to financially make your car payments.
What's the difference between a Chapter 7 bankruptcy and a Chapter 13?
Chapter 7 bankruptcy is known as a liquidation, and in a Chapter 7, assuming you meet certain criteria that your income is below the median income for the area, commonly referred to as the means testing, and also if you do not have the ability to pay back your unsecured creditors, you generally are going to qualify for Chapter 7. Now, you have to have an 8-year period where you have not filed a previous Chapter 7. So that would be an example of what a Chapter 7 is. Chapter 13 is known as a reorganization. In a Chapter 13, you are going to reorganize your debts, and you're going to pay some of the debts back, or possibly all of the debts back, depending on your financial situation. And in order to answer that question, Joel, we typically have to do a financial workup with a potential client to see where they fall in the gamut of Chapter 7, Chapter 13, or there are some circumstances of Chapter 11 filing for an individual.
And it would seem to me that in order to file a Chapter 13, you would have to be a wage earner, because you'd have to be able to be making continuous payments. Is that true?
That's what the bankruptcy statute says, but we've had many cases where people's only source of income is Social Security benefits or pension benefits. So in those cases, they're still eligible to file under Chapter 13.
Let me ask you this. How does the bankruptcy process begin? What's the very first step a person would take?
Very first step would be coming in and meeting with an attorney who's knowledgeable in bankruptcy and bankruptcy filings. And at that point in time, as I've discussed, financial workup needs to be done.
Now, let me interrupt you right there. We know in 2005 the Bankruptcy Reform Act was passed, and in that statute it was stated that individuals don't need to use attorneys. So could a person just do this on their own?
Theoretically, you could do that yourself, and in situations where you don't have much to lose, or very few assets, things of that nature, very low income, that is a possibility. In most cases that we deal with, people have assets that they're trying to protect. They're trying to protect their principal residence. They're trying to protect their bank accounts, pension plans, IRA accounts. They're trying to protect their cars and their furniture and things of that nature. So where you have assets to protect, I certainly would not recommend attempting to file a case by yourself. Bankruptcy laws are very complex.